Well, good morning, everyone. Happy almost Memorial Day weekend here as we come back again to talk about a very important topic today and welcome our guests here. We've got a big crowd today, and as always, my name is Doug Blizzard with Catapult, and happy to come back again and talk about something I know a lot of employers are affected by right now. I was talking to a CFO a few days ago, and their company imports all their equipment from China. So you can imagine where they are right now. Furloughs, layoffs, pay cuts, tremendous change going on for them. It's just, again, it's not really right or left. It's just there's change now, and they're having to figure out how to deal with that. And so that's why we come back again to talk about, how do we as HR professionals and leaders navigate this change, regardless of our political beliefs. How do we navigate this change and make the best decisions for our company? So, again, glad to have you here, like I said, and administratively, we will be happy to answer questions at the end of the day. So type your question into the chat. I'll be monitoring that. I may be able to answer some of them. Otherwise, we'll hold them to the end. We've got a lot to go through today, and that's the admin. So, without further ado, I'm very excited to once again announce Bob Saar, managing shareholder at Ogletree Deakins here in Raleigh, North Carolina. And we've known Bob for a long time. Before we both had hair, and the hair was not gray for me, at least. Here we are. Ogletree Deakins, as you may or may not know, is now our law firm for our prepaid legal plan. That change happened May 1st. Already getting calls from our members, so we felt like this was a nice compliment. Ogletree has put on our employment labor law for at least 30 years. And I just like the combination of you can hear them speak at labor law or employment law. You can hear them speak on things like this. You can now talk to some of their attorneys as well as part of our prepaid plan. And then when things get bigger, which they often do, now you've got one of the largest law firms in the country to help you take that bigger issue on down the path, whatever path that becomes. So very excited about that. Again, with that, Bob, I'm going to let you take it and look forward to your wise counsel as always.
Hey, thanks a lot for that introduction, Doug, and it's good to be back with everybody. I appreciate the Catapult folks allowing me to come back and kind of do a follow-up program to the one we did several months ago. Several months ago, it was just almost, in the first 60 days of the administration, maybe the first 30, and things were moving so quickly. Lots of questions were being asked, and we were able to address some of those. So I'm happy to be here today. Thank you. Okay, whenever I give a speech, I'm contractually required by my law firm to talk about the law firm for a moment. So I'm just going to throw this up. I suspect most of you have heard our name, and Doug just gave the explanation there. We're a large labor and employment law firm. That all that we do is work on management side, labor and employment law. We've got over 1,000 attorneys, and we're throughout the country and throughout the world, in Europe, South America, Mexico, Canada. We've got 3 Canadian offices. That's an area where we've really grown in the past year or so. And we've got 6 offices in that other country that operates a little differently than most of us in North Carolina. I'm referring to California, of course. We've got 6 offices out in California. So we are ready to handle any issues that anybody have that involve labor and employment law. Okay, with that unpaid announcement out of the way, now let's focus on the program. Everybody, if we were here in person together, I would ask the whole group to say, raise your hand if you know what this building is, and everybody would raise your hand. Even though surprisingly, if you were to look at that next to the Treasury Department looks very similar to that one. It's right next door on the left-hand side from the east wing of the White House. But when I put this picture up, building the program, it kind of reminded me of an interesting thing. I hope no one will accuse me of heresy this morning, but I thought of the quote, there's nothing new under the sun. And I would ask you, who knows where that quote comes from? It's been, referenced in movie titles before, but there's nothing new under the sun. It's actually a Bible quote. It's from Ecclesiastes 1:9. And the full quote is, what has been will be again. What has been done will be done again. There's nothing new under the sun. And what I think it really means is that human events and experiences, while they're unique, and certainly if you look at this picture and think about it right now, it's unique. It's often really a variation of what's happened already. It's sort of that Bible phrase to me emphasizes the cyclical nature of life and the repetition of patterns in history. So um, while there's a lot that's happening right now, and it seems like it's brand new and it's from left field and people don't understand what it is. I think if you looked at the broader context, you'd see that it's really simply a pattern of change. That's what happens in our system where the executive branch and is a political body, and when you have political changes, there are changes that occur correspondingly in the executive agencies that we as employers in America have to react to. So, but the White House itself, it still looks the same. And indeed, President Trump was there before. He was there 2016 to 2020. All these things have been done before to some extent. I just think we as humans have short memories, perhaps, and I'll bet that's not necessarily something that's mitigated against by our attention to social media and sort of the daily media cycle, the drive-by media on things rather than looking at things as long patterns. Okay, today is by no means, like Doug said, a political presentation. Do not mistake it for that. Yeah, I bet you'd have a hard time figuring out what my political beliefs are, believe me. But that's not it. As employers, we are reactive to the government, and the government is the big regulator and enforcer of the civil rights laws, all the rules from the various agencies. And so it's really important to understand what's going on and what these changes are. So my goals for today are to help you understand the executive branch changes as they continue to evolve and continue to be rolled out. I want to help you make sense of some of the new legal requirements and recognize that these things are they're new. They're babies right now. We're trying to figure out how they're going to be enforced and interpreted. But I want to tell you about the guidance that the government's providing right now so that you can incorporate that and you can identify what you need to be doing as leaders there in your business to prepare the business for the changes. Okay. Can you believe it was just 4 months ago? I think it was 4 months ago, almost to the day of the inauguration. Since then, you know, President Trump is off to, I put here in italics, an action-packed start, recognizing that people could use different adjectives to describe that, but without a doubt, it is action-packed. He's issued 152 executive orders. There are 275,000 fewer federal employees now than there were when he took office. There's been $160 billion that has been cut from the federal spend. And what that means is the legislative branch authorizes the expenditure of money, but the executive branch and the agencies are the ones that actually spend it. And so what the Doge group has identified is we're canceling about the spend of $160 billion. The Trump administration has effectively ended federal affirmative action, the Office of Federal Contract Compliance Programs, and then they've come up with a new term called illegal DEI that's becoming part of the common vernacular now. Even hear that on mainstream media talking about the difference between DEI and illegal DEI. There's new leadership in most of the agencies, the cabinet level agencies, the ones that are members of the president's cabinet, the Department of Labor, the Secretary of Defense, Department of Interior and Treasury, and so forth. Those nominees have all been confirmed at this point, and President Trump pretty much got the slate of nominees that he had asked for. The next level down of agencies are undergoing confirmation hearings right now before the Senate. So those have been going on this week. In fact, so if you watch the news in the evening still or look at it online, you'll see excerpts from those Senate confirmation hearings occurring. That's sort of the big thing that's going on, as well as the budget process, which the House has moved on this week. The Department of Education has effectively been shut down. You've seen the hearings with the Secretary of Education, the Wrestling Federation's wife, Linda McMahon. She's the Secretary of Education, and she's been before hearings this week on Capitol Hill, but that the department is kind of over. there's talk about President Trump wanting to acquire Greenland from the Danish, to talk about, what the relationship with Canada is. There are over 200 lawsuits challenging his actions so far. So I just, I've never in my life, and I can't imagine none of you have, none of us have seen such an action-oriented administration get off the ground. And I suppose if you have, I mean, look at what has happened here. He was president for 4 years, then he was out for 4 years. And during those 4 years, I think it's fair to say they came up with a game plan. So they came in and hit the ground running, and that's what they're doing. Let me talk very briefly about this last point, the over 200 lawsuits challenging his actions so far, because I want you to understand, even in the news today, there was news of a court in Louisiana issuing an injunction on certain parts of the enforcement of the Pregnant Worker Fairness Act. I want you to understand how this happens. So obviously, the executive branch is the federal government. The federal government is supposed to consistently enforce federal laws throughout the country. So, through the entirety of the United States, Congress passes a law. The words of that law are the same, whether you're in California or whether you're in North Carolina or whether you're in Louisiana. The words are the same. The enforcement by the government agencies should be the same, regardless of what state you're in. It's the principle that the federal law of the country is unified. It's all supposed to be the same. Now, the interpreters of that law are, on one hand, federal government agencies, and those are run by people. And we know that no two people are the same. In fact, it's rare to find two people that think similarly on most things. We're all individuals and we have different ideas, and that's the truth with the government enforcement and government leaders as well. So you have differences in interpretations of laws occurring by people, even though the words are the same. The same is true in the judiciary. And the judiciary's role is to oversee and resolve disputes about what federal laws mean in this context. So, a judge in California may decide that the federal law words mean one thing. A judge in Virginia may decide that those same federal words mean something else. But the current state of the law is that any one of the hundreds and hundreds of United States district federal judges, this is the trial court level judge who's appointed by the president, they serve a lifetime term, they're confirmed by the United States Senate, that any one of those judges can declare a federal law to be invalid. And because the federal law applies throughout all the states in the country, that one judge ruling can apply across the entirety of the country, even though the California judge may have never set foot in Virginia and may not know anything about this part of the country. That's the essence of having a federal law framework. It's supposed to be consistent. So what we see now is that there are federal judges who are issuing orders and injunctions, stopping things throughout the country. And that's, of course, creating great consternation to the executive branch and President Trump and the Department of Justice, and creating great consternation to members of Congress as well, because they look at it. And I think there's a logical point to this to say, how is it that if the president was elected and Congress was elected and they're to write rules and laws that apply throughout the country, how can one unelected judge issue an order that prevents or modifies enforcement of that law? And so right now, I'm telling you that the policymakers in Washington, D.C. are really grappling with on the one hand, wanting a consistent federal law throughout the country that will apply everywhere. And on the other hand, the fact that there are judges with different opinions on things, and you're going to get judges issuing orders that prevent the president and Congress from doing what they want to do. That's all part of the balance. You think about the scales of justice. To me, we've got three branches of government, and they're supposed to balance and provide oversight to each other. That tension is natural, but that's going on, and that's why you see in the headlines. There was a judge in Texas last week who declared part of a law to be invalid. And then the question was, well, is that applying throughout the country or is it just in Texas? And he came back and said, well, I'm just making my ruling effective to these parties rather than throughout the country. So you're going to see, when the first question to ask when you hear a headline that a judge somewhere has invalidated this part of the law, ask yourself, now I need to wait and see, is that effective just to these parties or across the country? I think we're going to see some retrenching where judges are generally making their orders more narrow and limited to the parties, or limited to a certain geography because of the policy pressures from the government right now. Okay, so with that, let me talk about another way that the government is really sort of walking in lockstep in a way that I've never seen before. The White House is controlling the agencies throughout the government, giving their strategic priorities and an action plan more than I have ever seen. Some of you may know I worked in the George H.W. Bush administration, 1989 to 1990, about the end of 1991. And the way that the administration at that time, under President Bush, sort of set strategic priorities throughout the government was there was a meeting every week called the deputies meeting. And that was the number 2 person in every cabinet level agency would get together in person in the White House, in the Roosevelt Room, and they'd sort of go around the table. I sat in on these meetings sometimes. They'd go around the table, sort of tell what each agency's doing. They were coordinating, but in a loose manner. The agencies were really free to do what they wanted, as long as they weren't getting too far out the boundaries of what the president wanted them to do. Here, with this, what the president has done is he signed an executive order called the Ensuring Accountability for All Agencies. And what it's really done is it's given the White House explicit control over the agencies, which they have. This is all lawful. It's just a different, tighter control that's being implemented by this administration than what I've seen before. And what it requires is the agencies have to submit for review and approval all proposed and significant regulatory actions. The director of the Office of Management and Budget, who sits in a building, sits in an office inside the White House complex himself, is to establish performance standards and management objectives for all the agency heads, and then really to monitor what's going on just in a tight, close way. So I think on the executive branch of things, what we're seeing is a very consistent approach being taken by the agencies. And that's not to say there won't be inconsistencies, but it's a much more consistent, cohesive approach than I have seen before. And of course, I mentioned earlier the 275,000 jobs that have been eliminated. There are even more that are likely coming, of course. That's a goal of this administration, to shrink the size of government. They've done that in a couple ways. They've required people to come back to the office, and I think the media has well publicized the fact that that was a disincentive for a lot of people to return to work. There have also been memos going out instructing reductions to take place, with the Department of Education being the most prominent of those, and the probationary employee terminations that have occurred throughout the entirety of the government. Executive Order 10 is an interesting one that I just wanted to call to your attention briefly. And what it says is that for any agency that has a new rule, so let's say the Department of Labor Wage and Hour Department wants to issue, or division wants to issue new guidance and regulations on independent contractors. In order for the Office of Management and Budget to approve that regulation to go out or that guidance to go out, the enforcement guidance to go out, the Department of Labor Wage and Hour Division would be required to identify 10 prior such issues, such directives and instructions and interpretive guidance that should be revoked. So for every new regulation, every new proposed instruction, they are to identify 10 existing ones that they will rescind. So that's a interesting way to go about it, and it's something to be mindful of. That anytime something new comes out as a directive from the federal agencies under the Trump administration, go back and check your notes, because there are 10 other ones that are going away. All right. So from the government agencies, the ones that impact us as HR professionals and labor attorneys most directly, really, we think about the EEOC predominantly. That's sort of the biggest one and the most likely one for you to encounter, and that you're trying to ensure that the business lives up to its obligations under their regulations and rules. The old saying in Washington is that personnel is policy. So let me tell you who the personnel people are right now. The acting chair is Andrea Lucas. She was appointed during the first Trump administration. The EEOC commissioners serve a set term. Um, she was a corporate labor and employment attorney, much like myself. She went to the University of Virginia, and she's now the acting chair. Uh, the other commissioner, and there are five commissioners, there are only two spots that are filled right now, is Kapana Katagal. She's a Biden administration appointee. The other three spots are open. And in what may provide the EEOC, well, so with only two of five commissioners, the EEOC as a body cannot issue any new rules or instructions for employers. It takes a quorum of that five-person body to act. So they need three people in order to do something. They've only got two right now. But now the president has nominated a assistant U.S. attorney from South Florida, Brittany Panuccio, to be the third EEOC commissioner. And if she's got to be confirmed by the Senate, but if she's confirmed, that would give the EEOC a quorum. Um, and then they could go forward with rulemaking and policymaking and issuing new guidance that advances the president's administrative agenda. And they could also, in that event, go ahead and officially rescind guidance that the EEOC had previously issued. So, we anticipate that based on statements that Acting Chair Lucas has made and other informal guidance, that once the commission has a quorum, it's going to make certain types of charges, litigation, and other policy matters a priority. So they're going to issue a strategic priority area. And the prioritization is probably going to include, number one, focusing on investigating and litigating with an expanded definition of what constitutes an adverse action when considering DEI programs. Um, so, for example, where a DEI program results in one protected class failing to receive the same or similar mentorship or feeling ostracized or discriminated against because of the programs, it seems relatively clear that the EEOC is going to enforce Title VII to investigate and remedy such programs. Um, Obviously, we've never seen that type of enforcement priority before. We also think that they're going to work on eliminating systemic case investigations and the litigation of otherwise neutral employer policies that may have a disparate impact on a protected class. And stick a pin in that because I'm going to talk about disparate impact liability on my next slide. The bottom line is we think that that's not going to be a priority of the government, and I'll tell you why. We do think that the EEOC is going to eliminate the recognition of gender identity as it relates to the EEOC's sexual harassment guidance that was issued during the Biden administration and other guidance, particularly concerning restrooms and locker rooms and sleeping quarters and other sex-specific workplace facilities, which in the view of the acting chair, she says that guidance impinges on the rights of women. Also think the EOC is going to eliminate existing policy guidance and regulations associated with abortion as a pregnancy-related condition under the Pregnant Worker Fairness Act. The EEOC is also, I think, going to increase its focus on the investigation and litigation of employment discrimination based on religion and national origin. So, and race, and I think that will be in a different way than before. So, national origin, I think, they're going to focus on Judaism and Americanism. Race, I think they're going to focus on employees who feel that they're being excluded because of employer DEI programs or affirmative action type of programs. And sex, I think they're going to particularly focus on employees who believe the focus on gender identity and transgender rights and sexual orientation is impinging on their own rights. So it's a different type of enforcement initiative. Um, The acting director, Ms. Lucas, has also said that under her leadership, the EEOC will follow and enforce the law and will prioritize remedying intentional discrimination claims. So a change from sort of disparate impact, systemic focus, sort of the hidden type of bias theories that exist, and focus on ones that the administration would say are just on their face, sex discrimination or racial discrimination. Again, this lack of a quorum has prevented the EEOC from investigating charges right now, consistent with this change in perspective. But that's going to change real quickly. So if you have experienced a systemic investigation or have charges alleging disparate impact, what you might have noticed is there's sort of a cooling off period right now where the government's not doing anything. They're not dismissing those charges. They're not issuing a no cause finding in favor of the employer, but there's not much activity. I've got several that are in court being litigated with the EEOC that I'm personally handling around the country. And the trains have just stopped moving within the government on those things. And in some cases, the government employees who were pursuing those aggressively have left the government. So I'm waiting on the quorum for the EEOC to dismiss those lawsuits, and I think they will. What's on the horizon? I've got the PFWA changes. Well, the Pregnant Worker Fairness Act was a significant piece of legislation that was enacted about 2 years ago. The regulations are about that thick. But my takeaway on those after digesting them and listening to some smart people talk about them is that it really requires you to accommodate, as an employer, to accommodate a pregnant employee in most ways that they or you could think of. Doesn't have to be their preferred accommodation, but there are a lot of things that we need to do as employers. I think what's going to change on that is that does include abortion as a pregnant condition that you'd have to allow accommodation. I would suspect that the EOC regulations are going to get rid of that and say abortion has nothing to do with pregnancy. So that's a change to be on the radar screen for looking out for. I promised that I'd talk about disparate impact liability. Let me make sure everybody knows what that is first. So disparate impact liability refers to a legal doctrine where employers or other entities may be held accountable for a specific employment practice or policy that, while it's neutral on its face and is not intended to discriminate, instead causes a substantial adverse impact to a protected group, maybe such as sex, and can't be justified as serving a legitimate business goal for the employer. Disparate impact liability has been a key component of federal anti-discrimination law and has been upheld in multiple landmark court cases. And in fact, it's codified in Title VII as part of the Civil Rights Act of 1991 that President George H. Bush, who I worked for, signed into law. However, the executive order that I mentioned here, the Restoring Equality of Opportunity and Meritocracy executive order signed in April, states that it is the policy of the United States to eliminate the use of disparate impact liability in all contexts to the maximum degree possible to avoid violating the Constitution, federal civil rights laws, and basic American ideals. And specifically, that executive order orders that all government agencies should deprioritize enforcement of all statutes and regulations to the extent they include disparate impact liability, including Title VII. It directs the Attorney General and the EEOC chair to assess pending investigations, civil suits, or positions taken in current matters that rely on theories of disparate impact liability. So that's why I told you a moment ago that I expect the EEOC to drop those matters and once a quorum is in place with the commission. It's just not, they've been instructed to do so and they will do so. The executive order further revokes presidential approval, and I'll put that in quotes, of key regulations carrying out Title VII of the Civil Rights Act of '64, which prohibits discrimination and in programs and activities receiving federal assistance. So that, what does that mean? It means that as a government agent, from a government agency perspective, that type of theory, a neutral policy that may impact individuals in a protected class in a disproportionate manner than their representation in the population applicable to the employer and applicable to the area where they live, the government's not going to pursue those. However, Private individuals may, of course, still file lawsuits making those claims, and they will. I think that's what will happen. You'll see an increase in uh, lawyers and activist organizations and individuals raising those types of claims without the government's working to investigate them. So I think in some cases it could turn out to be that they're more frivolous type of claims filed on those matters, regardless of whether the government investigates them or not. As in the past they have investigated those claims. The government acted as a little bit of a filter to those, right? So I mean, when the EEOC looks at it, we're not going to agree they get it right all the time or they get it wrong all the time, but that is somewhat of a filter to someone that they go to the EEOC, make this claim. If the EEOC told them it had no merit, they were less likely to file a lawsuit. But now, without the EEOC being in the position of sort of being a filter and being a stopper of those things, I think they may just go right on and file lawsuits. And most state laws also will have a disparate impact theory that's apart from this federal law that we're talking about. Let me mention the EEO1 form. So this is kind of interesting to me. In the EEO1 submissions, this is for employers of a certain size that have to report demographic data to the Equal Employment Opportunity Commission. I kind of thought initially that the Trump administration would stop this reporting, but they haven't. They opened it up, I think, earlier this week. It's a website that you go to, and it's open for submissions. They've shortened the time period for submissions, but what they've said is that still, and if you've got 100 or more employees or federal contractors with 50 or more, you've got to submit this report. You know that. What acting director Lucas has said is she's warned that let me just quote for you exactly what she said. Obligations under Title VII are not to take any employment action based or motivated in whole or in part by an employee's race, sex, or other protected characteristics. She said, essentially, still reminding employers, don't look at this data and say, oh, we're woefully underrepresented in this particular race, class, or other trait, and then actively go out and recruit those people. She's saying there is no diversity exception to Title VII. So the idea that we want to that you as an employer want a diverse population doesn't immunize you from Title VII liability if you're making decisions based on race or any other protected characteristic. So there's, that's, you need to know that. Okay, let's talk about the other kind of hot flash issues that have cropped up. Executive Order 14168, it's called the Defending Women from Gender Ideology Extremism and Restoring Biological Truth to the Federal Government. What that is, it established that the government as a federal policy recognizes two genders, male and female. This executive order instructed the EEOC to rescind portions of its harassment guidance that were inconsistent with that order. On January 28th, Acting Chair Lucas rolled back much of the Biden era technical assistance relating to discrimination and harassment against LGBT plus individuals. However, and that was technical assistance that she could go ahead and roll back unilaterally. The enforcement guidance that the EEOC had issued under the Biden administration along those same lines has not been rescinded and won't be rescinded until the EEOC gets its quorum. And then I think they'll do that very, very promptly. Talked about the impact of the federal district court judges and national injunctions or national revocations of laws. Here's an example of that. On May 15th, a federal court vacated portions of the EEOC harassment guidance, specifically guidance based on sexual orientation and gender identity. It was in the Northern District of Texas, and what the judge said is that the EEOC had overstepped by stating that Title VII's prohibition on sex discrimination also prohibits discrimination based on sexual orientation or gender identity. The EEOC's guidance, however, had flowed from a Supreme Court case in 2020 called Bostock. And in Bostock, Title VII, the Supreme Court of the United States ruled that Title VII prohibits employers from firing employees for being homosexual or transgender. The court specifically held that an employer who fires an individual for being homosexual or transgender fires that person for traits or actions it would not have questioned in a member of a different sex. Sex plays a necessary and undisguisable role in that decision, exactly what Title VII forbids. And the court's key holding in that Bostock case went on to clearly state that it's impossible to discriminate against a person for being homosexual or transgender without discriminating against that individual based on sex. Following that Bostock decision, the EEOC published guidance in 2021 stating that employers couldn't deny employee access to bathrooms, locker rooms, or showers aligning with gender identity. Also that 2021 guidance also talked about misnaming somebody and misgendering people. And so that's kind of where things were. But now that guidance has been challenged and ruled invalid in court. I think this Texas court case is one of those where it came out initially as a national injunction, and then the judge came back and issued a subsequent order saying, actually, I'm just doing that within my own jurisdiction. So I don't think there's a national injunction against that interpretation, but you can certainly look at which way the wind is blowing on those types of issues. And of course, the fundamental reason we have to go through this different interpretation and different policy guidance that to some extent flip-flops back and forth now is because the law itself, Title VII, the federal law passed by Congress, doesn't say anything about LGBTQ issues. It's completely silent on that. It says sex. And so the courts and the government have to interpret what sex means. And that's why you may say, why is this unclear to begin with? That's why. It's because of the imprecision of the English language as passed by Congress. Let's talk about DEI executive orders real quickly. So there have been at least three. There's the Ending Radical and Wasteful Government DEI Programs and Preferencing. There's the Defending Women from Gender Ideology and Extremism and Restoring Biological Truth to the Federal Government. And there's the Ending Illegal Discrimination, Restoring Merit-Based Opportunity. I mean, aren't these great? These are great names on these orders. If you read the name itself, it's hard to disagree with them. But then when you read the order itself, you wonder where the name came from, I think. But also that's kind of where we are, and we got from that the follow-up executive order that was the one establishing DOGE, which is kind of I think some people call it a DEI attack dog group, but there are currently a lot of legal challenges about what DOGE is doing. But all these executive orders directed the government to investigate, identify, and eliminate illegal DEI programs. And an illegal DEI program, again, would be one that that favors one group to the exclusion of another. It's just that simple under the current administration viewpoint. So I put together this little slide, which is just a grid to sort of summarize this. The private sector employers in those orders is not defined, but it seemingly includes any employer subject to Title VII. So the private sector is referenced in those DEI orders are federal contractors, federal grant recipients, and employers with no federal business even. But if you're subject to Title VII, Section 1981, you're covered by the language in those orders. It directed initially, and it directed initially the Attorney General within 120 days to create a strategic enforcement plan identifying targets for illegal DEI in the private sector. That means actual company names that are going to be prosecuted or investigated for illegal DEI, and they'd be prosecuted if they failed to reach an agreement or the government found that there was a problem. Each agency was required to identify its most egregious DEI practitioners in their own sector, who they would say are engaging in unlawful DEI activities, and to refer to the Department of Justice for civil compliance investigations, 9 or 10 companies within their field of regulatory scrutiny. So the 120 days there expired like on Monday or Tuesday of this week. And what a client sent me is this memo that you can see, which sort of got a little bit of news play, but it's more important. It should have gotten more news nationally. It's a memorandum from the Civil Rights Division at the United States Department of Justice. I worked in the Department of Justice Civil Rights Division for a brief period, and that is a massive, massive, very important department to DOJ. They have many, many, many judicial resources and can impose quite a hammer on violators of the law. But what it says is the Department of Justice is launching a civil rights fraud initiative. It's a coordinated enforcement effort aimed at using a law called the False Claims Act to investigate and, where appropriate, litigate civil rights violations committed by recipients of federal funds. That effort reflects a significant escalation in the federal government's posture towards civil rights compliance and underscores expanding legal exposure for employers, contractors, and institutions who operate under federal grants or contracts. This memo went out to businesses that receive federal funds at some level. The client who sent this to me was a university. So that, I mean, what it makes clear that civil rights non-compliance is going to be treated by the Department of Justice as a form of fraud. Specifically, it's aimed at those who defraud the U.S. by taking money while knowingly violating civil rights. That's kind of the linchpin to pursuing employers under this law. You got money, you're violating federal laws, that's fraud. This is a law that has real teeth to it. Massive damages can be awarded, injunctions can be awarded. It's really the type of calamitous event for a company to face scrutiny under. We defend a lot of these cases, but they're high risk. So that's something you need to be aware of. It also, if you're making government certifications back to the government, I think this signifies that the Department of Justice is drawing a direct line from civil rights violations to material falsehoods in any government certifications. Let me give you an example, and I'll do it from the university context. The memorandum itself warns that a university could face False Claims Act liability if it encourages anti-Semitism, refuses to protect Jewish students, or allows men to intrude in women's bathrooms, or requires women to compete against men in athletic competitions. So in any event, the government is not just giving lip service to these anti-DEI initiatives. They're empowering the Department of Justice to go after businesses that are deemed to be violators. Okay. I've spent, now a good chunk, 2/3 of this program talking about just regular EEO employment law type of changes that are out there that you need to be aware of. And I'm obviously haven't gone through all of them. I've really tried to hit the ones that I think you need to pay the most attention to, because these are the ones that I think the EEOC and the other government agencies are paying the most attention to, and the ones that I think have the most risk for you. But let me talk about traditional labor law a little bit, because that's an area that we're used to wide variations from political administration to administration, and even differences between leaders of the same party as they come into the administration to really change the course of how traditional labor law is interpreted. And what I'm talking about, of course, is the National Labor Relations Act, which is the law that gives employees the right to collectively bargain and pursue rights. The status of the National Labor Relations Board is that right now we've got 2 of 5 people. So there are more that will be nominated and will be designated, and there'll be a board that can act and give policy guidance, kind of the similar manner to what I said about the EEOC. But we do have a new acting general counsel of the National Labor Relations Board. And that's a key position, because the general counsel of the National Labor Relations Board different from other government agencies, really is the lead enforcer and policy guider of how the board's going to act. The prior general counsel, Jennifer Abruzzo, was a prominent union rights attorney who shifted the policy of the board strongly to favor collective bargaining and impose restrictions and difficulties for employers to remain union free. Cohen is a little bit different, but he's just going to be a temporary inhabitant of that office. He's there right now while the new nominee, who is a management side labor attorney, is up for nomination. And so I would expect that she'll be confirmed. I don't know her personally, but I'll bet she is. In the meantime, Cohen, the acting general counsel, has hit the ground running, and he's off to the races doing things. Here's a memorandum. Let me give you a better screen of this. I'm going to draw out part of it to you. This came out back in February, so almost immediately after the president took things over, this was issued. What he says is, over the past few years, our dedicated and talented staff have worked diligently to process an ever increasing workload. Notwithstanding these efforts, we've seen our backload of cases grow to the point where it's no longer sustainable. The unfortunate truth is, if we attempt to accomplish everything, we risk accomplishing nothing. And with that, underneath that, he rescinded 18 prior general counsel memorandum and named others as rescinded pending further review. So with that, a couple of sentences as the predicate. I mean, look at the subject line: rescission of certain general counsel memorandum. With those sentences, they went in and basically wiped out everything that Jennifer Abruzzo had done in the prior administration. Okay, so let me give you some specific points to talk about how things have changed from issues that you've probably read about, certainly in publications, and maybe heard lawyers at our firm or others talk about, because labor law had changed a lot in the past last decade, really, but 4 years. The first area is he rescinded instructions to the National Labor Relations Board about what type of remedies to seek when violations were found. What we saw in our practice is that there was an increasing amount of grievances being filed by unions and unfair labor practice charges being filed by people both with unions and without unions that the office was investigating. And in North Carolina, as you know, the National Labor Relations Board office is in Winston-Salem. They operate, I mean, think of them like a similar an adjunct entity to the EEOC. They don't enforce the same roles. They're not the same, but just realize it's a government agency that gets charges from employees, investigates, then enforces those charges. That's what the National Labor Relations Board does. And they were instructed under the prior administration to seek a full panoply of remedies available in unfair labor practice cases. They were instructed to seek full and effective settlements. And what that meant is the remedies that the National Labor Relations Board was seeking for an unfair labor practice charge were greatly expanded. They were pushing the boundaries of what the law would allow. And so I think what this means is you're going to see a return to the remedies that the NLRB would have sought about, 8 years ago or so, returning to standard remedies such as back pay, interest, reinstatement, posting of employee notices has always been a large resolver of unfair labor practice charges. And under the Biden administration with General Counsel Abruzzo, they were pursuing remedies like automatic instatement, automatic institution of a union for violations. I don't think they'll be doing that anymore. And the board under Abruzzo's guidance was not allowing employers to resolve charges with non-admission clauses. That would be statement in the resolution documents, the legal documents, saying essentially we're resolving this without admitting liability. They were insisting that liability be conclusively established to settle a charge. I think we'll probably go back to where you can do it without admitting liability, which is certainly much more favorable for a business. It allows you to resolve things without admitting there was a problem, which is important because most of the time you resolve it, you probably don't believe there was a problem in the first place. You're just trying to resolve the issue and move on with the business of the company rather than engaging in long litigation with the government. Um, Electronic monitoring was a National Labor Relations Board issue under the prior administration. The concern was that anything you're doing to track the movement of your employees, et cetera, could impinge and inhibit an employee from exercising their right to engage in activity lawful under the National Labor Relations Board, under the National Labor Relations Act. I think this is something with the rescission of that memo that will go back to a prior standard, which is there's going to be less National Labor Relations Act scrutiny on employee monitoring. It's going to limit the scope of an employee's Section 7 rights under that law. One that got a lot of attention was a memo that it was a board decision, and then a memo called McLaren-McComb. In the vernacular. And what that really said was the National Labor Relations Board looked at any sort of confidentiality and non-disparagement clause in settlement agreements as a presumptive violation of the National Labor Relations Act. You may have had, and you may have instructed you, as you go through your forms annually, which I would strongly suggest you do. So if you've got a stock settlement agreement or general release you're going to provide to any employees, you need to keep that updated annually. And you certainly need to update it when a new administration comes in because there are changes like this. I would guess that most of you revised your settlement agreements during the past few years to probably have two types of settlement agreements with employees. If you're settling a dispute with a supervisor, you probably had pretty firm non-disparagement and confidentiality language. But if you were settling a dispute with a non-supervisory employee, you probably either absolutely removed that language or really watered it down. And that was because of the instruction from the National Labor Relations Board in the McLaren-McComb issues. That has been rescinded now. So I think that you can go back to the language that we would have used maybe 5 years ago in settlement agreements and insist on strict confidentiality and strict non-disparagement. Now, I'm reading the tea leaves a little bit on that. This is that they've rescinded a general counsel memorandum, which gave interpretive guidance and instruction based on this case, McLaren-McCombs. The McLaren-McCombs case has not been overruled yet. But once there's a quorum on the National Labor Relations Board, they can do that. But I just want to point out that nuance to you, and you can see which direction things are going, which is going to open up, it's going to unlock employers' hands a little bit in terms of crafting settlement agreements. The prior administration's National Labor Relations Board really, in fact, they said it was illegal to have what they called captive audience meetings. And what this typically was, if you have a union campaign that occurs, you want to have your employees attend a meeting that you pay them for. It's during their workday so the leader of the business can stand up and explain, listen, I don't know what you're being told by the union people, but here's why we don't need a union. And that's a fundamental plank of how to engage in a union campaign from the employer's point of view to try and achieve the employer's objectives of staying union free. It's very important. Ms. Abruzzo, as general counsel, had said that those meetings are illegal, and she called them captive audience meetings, kind of like a captive audience when you require your employees to come to work each day. They're captive, they're working, but that was what she said. That's a change that I would predict the board's going to overrule that. The National Labor Relations Board was also really looking at, I mean, if you read their cases during the past 4 years, they were classifying some pretty extreme and horrendous employee misconduct as protected conduct under the National Labor Relations Act. So employees engaging in just these incidents of extreme profanity and screaming and throwing a fit on the job and walking out, the National Labor Relations Board was saying, well, that's actually protected conduct. You can't discipline them for that. I think that's going to change. But not everything's going to go away. I don't want you to mistake this for, okay, Bob is saying that union campaigns are going to go away, because I don't think that will happen at all. Let me kind of give you a forecast why. I said personnel is policy earlier. Let me tell you about the Secretary of Labor, Lori Chavez DeRemer. She's a pro-union U.S. Department Secretary of Labor. President Trump is, can be certainly shown to have some pro-union tendencies. Some of that goes with his populist campaign, but his support by the Teamsters in the last election. The Secretary of Labor co-sponsored the PRO Act, which is a union organizing act, as a member of Congress. She sponsored a law to protect organizing rights of public sector workers in California. The Deputy Secretary of Labor, Keith Soderling, he's a former EEOC commissioner. He kind of provides some balance, and we'll have to see how this shakes out. But just realize that the Secretary of Labor for the United States is probably pro-union in most instances. So I don't think I think policy will reflect that. There's also Senator Hawley, who's a Republican, and he has circulated and proposed legislation that is pro-worker friendly. His proposed law, this is not law, but his proposal, is that you've got to have notice posting for employee collective bargaining rights. He would ban captive audience meetings. He would have what we call the ambush election period, which means shortly after a petition is filed, there's going to be a union election within a matter of days or weeks. And that's important, because the shorter the period of a election period, a campaign period, generally the shorter it is, the more likely it is for the union to win. The longer the period is, the more likely it is for the employer to win. That's because the employer has the opportunity to explain to the employees, once you know that there's a union threat there and a petition's been filed, can explain why joining a union doesn't make any sense, why it's unnecessary, the business case for there being no union representation. So I just want to point that out, because you would think that normally when a Republican administration comes in, the National Labor Relations Board and unions really are, they're kind of on the losing side of the fight, if you will. I think there are changes. There are going to be changes with the rescission of all that guidance, but I would not go so far as to say that the time for unions is really going to diminish again. I think there's still going to be substantial support from the government for workers in certain industries to unionize. Employee benefits is an area I wanted to mention. Again, the personnel is policy, and we're waiting to see who the heads of the agencies that enforce and regulate employee benefits are yet. But we're going to see the impact of the deregulation, that 10-for-1 rule. We're going to see the difference in the Chevron interpretation, which is that Supreme Court case I talked about last time, and certainly have talked about at our employment law updates on how much deference is to be given to the government's own interpretation of its own regulations, which are interpreting the federal law. The Chevron case said that deference was to be respected. The Supreme Court changed that rule in the last year, saying in the Loper Bright decision, saying that the government's not necessarily entitled to any deference on the interpretation of a law passed by Congress. And we're going to have to see how the agencies can enforce things when the staff people are being cut or leaving or voluntarily retiring. On the health plan side, let's think about the Mental Health Parity and Addiction Act. That was the one that was a new federal law, a recent federal law that said if a health plan offers coverage for mental health and substance use disorders, it must do so in a manner that's comparable to the coverage provided for medical and surgical care. we'll see about that. There'll be new final rules that'll be issued by the new administration, and I'm not sure if that will be there or not. So you've got to stay tuned on that one. Reproductive care provisions in the law. My forecast would be that a lot of that's going to be out. That's just wrapped up, and of course, in the abortion debate. And the President Trump has said he's anti-abortion. ESG investing and the sort of favored status of that, is that going to be out? And that ESG, that's environmental, social, and governance investing. I think it's probably going to be out. We'll see. But we have a new czar of cryptocurrency within the government. So I think that I wouldn't be surprised to see if the government agencies don't incentivize cryptocurrency as an offered benefit in 401k plans and that sort of thing. Okay, so real quickly, let me wrap up by saying there's a lot, and there's going to be a lot more, and the hits are gonna just keep coming and coming and coming. We've set up on the Ogletree.com website a new administration resource hub. It's if it's not every day, it's every other day. There's a posting by one of our experienced attorneys on a subject matter niche to labor and employment law on something new that the government's doing. So I would encourage you to stay up to date on these things by regularly checking that blog to get the true and real story, and not the one that's being reported necessarily on whatever your favorite media source is. And the final thing that I want to mention to everybody is that we have got the annual employment labor law update coming. We've done this program for at least the 30 years that I think I've done it, for 29 years that I have done it. It is August 21 and 22 in Charlotte, and September 4 and September 5 in Raleigh. An in-person event, a great networking opportunity. It's really fun for our team and our lawyers to come out there and actually shake hands and see people in person, and answer questions in between sessions, and get to engage with all of you all. We've got a fantastic program put together that I think you'd really enjoy. So I believe that's a QR code that you can scan, and I'm sure that leads you to the ability to sign up for it. So with that said, my time is up. Thank you so much. I've enjoyed being here today.
Thanks, Bob, as always. Great information. As you saw, some things might be good for employers, not so good. Good for employees, not so good. A lot going on, though. And I really hope you view us as the combination here with Catapult and Ogletree is kind of your HR safety net. Tools, resources, guidance. Please reach out. You're members of ours. You paid for it. Love to talk to you. And with that, good luck in the coming days and weeks. Have a good weekend. We will see you next time. Take care.
I didn't see any I didn't
No,
I didn't see any questions.
no questions. Are they still hearing us? There's still 27 on here. They're slowly going away. No questions here. They can obviously still hear us.
Yeah, probably.
All right, I gotta run to a meeting. Great job, y'all.
All right. See you,
See y'all.
Doug.
Thanks, bye.
Can't hear you. You're on mute.
Enjoy the rest of your day.
You too. Bye.
Bye. So